Hey everyone, welcome to another episode of Darshan Talks. Today's interview is brought to you by the Kulkarni law firm, and hopefully we'll have more sponsors soon. I do want to say that today's interview is going to be about non-therapeutic uses of drugs, which I think is a fascinating topic. I happen to be lucky enough to have someone who understands the topic and can explain, because let's be honest, this is not my core area of expertise. Our guest today is an associate professor of law at the Ohio State University. I didn't realize there was a but the Ohio State University. Among other things, she also serves as a member of the board of directors for the Food Drug Law Institute, which is FIDLI, and is a co-author in the forthcoming 5th edition of Food and Drug Law Case and Materials with Peter Barton Hutt, the late Richard Merrill, Louis Grossman, Nathan Cortez, and Erica Lietzen. Before entering academics, she served as associate chief counsel in the FDA's Office of the Chief Counsel. Just to remind everyone, she is an associate professor of law. However, nothing either of us is saying is legal advice. It is also not clinical advice. It is for educational purposes only and does not create an attorney-client relationship. If you have any questions, please feel free to reach out, ask our guest questions. Please also leave a comment, and subscribe by hitting the bell icon and share. It helps with the YouTube algorithm. You can find me on Twitter at DarshanTalks, or you can just go to my website, DarshanTalks.com. Patti, one of the things we did not do, unlike normal, I kind of gave the lead line away, but our guest today is Patti Zettler. But Patti, one thing we didn't do that I want to take care of is, how can people reach you?
Sure. So people can reach me on Twitter. I'm at pzettler, or at my Ohio State email address. If you Google my name, my Ohio State bio comes up. There aren't other Patti Zettlers at Ohio State, but it's zettler.25@osu.edu.
Perfect. And thank you so much for coming on, and welcome.
Yeah, thank you so much for having me. I'm really delighted to be here to chat with you and your audience.
Awesome. So, Patti, let's start from the beginning. When we say non-therapeutic uses of drugs, that's kind of a misnomer in that when I think about drugs, a drug is with the intention of treatment. So how do you sort of reconcile those two things?
Yeah, so that's a great question. So among other things, I teach legislation and regulation at Ohio State. So I teach statutory interpretation. So I get really excited about thinking about the specifics of statutory language. But in FDA statute in the Federal Food, Drug, and Cosmetic Act, a drug is defined as an article intended to diagnose, treat, prevent disease, etc., or intended to affect the structure or function of the body, excluding food. So it's that intended to affect the structure or function of the body piece of the statutory definition that's really quite broad. It can capture things that are not explicitly addressed or explicitly intended to address disease. So it could be something like your antiperspirant that you wear, which is intended to affect the sweat function of the body, or it could be something like a product that's intended for, recreational drug use, or, a high of some sort, something like that.
So what you're saying is cocaine, for example, for argument's sake, has a drug use. It's actually used, and I've actually made cocaine eye drops for compounding reasons. And not for recreational reasons. I'm not sure what recreational eye drops have. But
perhaps we needed an extra disclaimer for this conversation. Everything
exactly
right.
Having said that, there are, for example, psychedelics and cannabis and stuff which do not have an approved FDA indication. And I guess my question for you then is that, first of all, what we're talking about, or is there something else in mind? Are we talking about heroin, for example?
Yeah, so I think there's a couple of ways to think about that question. So one is that things that we might think of as street drugs or traditionally illicit drugs, like cannabis, which is still, a Schedule I drug, or psychedelics or heroin, usually when the federal government is seeking to prohibit distribution of those drugs, it relies on the Federal Controlled Substances Act because they are listed either by DEA or in the statute itself as controlled substances. But FDA statute is broad enough to capture things that are intended for recreational drug use. And so there are times where the federal government relies on FDA statute rather than the Controlled Substances Act to go after distribution of recreational products. It may be because typically it's because the particular product is not listed as a controlled substance under the Federal Controlled Substances Act. So maybe it's that someone's marketing a brand new kind of substance that hasn't yet had time to be scheduled, or is marketing an analog of a chemical that is scheduled or something like that. But there are times where FDA has sent warning letters to companies marketing products as sort of street drug alternatives. There's also times where the federal government has prosecuted the distribution of recreational products using FDA statute when the substance is not controlled. But when we're thinking about drugs that also have medical uses, like potentially psychedelics, of course, are right now of a lot of interest and are being studied, or cannabis and so on. That's part of why we frame it as uses, right? FDA approves a particular use of a drug, not the drug itself. And so even if psychedelics were approved, or a psilocybin product, for example, were approved for treatment-resistant depression or something like that, there might still be recreational products with similar ingredients marketed.
So that's the key piece, isn't it? It comes down to the, and I'd be curious on your take on this. My position would be, or my understanding would be, that in those situations, what you're really going after is the mislabeling part of the statute, where you're saying that the drug was unapproved, and since it's unapproved, the advertising associated with it is therefore mislabeled, so the product needs to be pulled back, or whatever actions need to be taken because the product is mislabeled. Is that the primary focus, or is there a different way the FDA tends to view that?
That's a good question. I mean, definitely, I think typically if we're talking about an unapproved prescription drug that is being marketed, it is also by definition misbranded. I think maybe there are sort of two avenues to think about. The government might be interested in using FDA statute because of that broad drug definition intended to affect the structure or function of the body to prevent the distribution of recreational substances when they're not a controlled substance for whatever reason. But there's also a question about, as people out in the world, not even just in the food and drug law community, I'm sure we're all, of course, aware that there's interest in descheduling or cannabis. There's interest in legalizing drugs, cannabis specifically, but other drugs as well, that's happening at the state and local level. And so I sort of got interested in this topic a little bit about the question of, well, what happens next, right? So if we do deschedule cannabis or other drugs, what happens next? How do we regulate them? Who regulates them? What happens to FDA's authority? And I will give a plug for one of my co-authors on the casebook you mentioned, Erica Litzen. She has a great article with another professor named Sean O'Connor about just how broad FDA's authority is over the cannabis marketplace if cannabis were to be fully descheduled and there were to be no changes to FDA statute. And I am blanking on the specific title, but if you Google Erica Litzen and descheduling cannabis, I'm sure you'd come up with it. But just a plug that she has a really wonderful article on that topic.
Which I think is really interesting, because my thought process is that people have been asking for the descheduling of cannabis and the fact that it'll make things so much easier because things will be quote unquote legal. And my position has been, be careful what you ask for, you just might get it. And the very simple logic is, the moment you land up in a scenario where you're telling the FDA, you now have jurisdiction over this. Now you start getting into OPDP issues. You start getting into unapproved drugs issues. In fact, there's an Office of Unapproved Drugs, which surprises a lot of people. In your experience when you worked at FDA, what was their jurisdiction? How did they play into the scenario?
I mean, so the Office of Unapproved Drugs specifically, or just I don't know. I didn't have a ton of experience with that office specifically, but I think in general, right now, the products that have non-therapeutic uses that FDA has reviewed and approved tend to be aesthetic uses, right? Botox for face wrinkles, dermal fillers that are devices, those kinds of really quite, I think, profitable aesthetic uses. And so FDA, I don't think, has done a lot of thinking or has had reason to do a lot of thinking about how it would regulate legal recreational products that are being marketed, because FDA or no FDA, right, these kinds of uses have been, or these kinds of products have been historically illegal. So one interesting thing, though, I think that's happening now with cannabis and thinking about reform is, there was a draft bill that came out about a year ago now, a little less than a year ago now, that would create a Center for Cannabis Products at FDA. So Congress is starting to think about, well, what happens next if we do decriminalize cannabis, and what role would FDA have? So I think that's an interesting question. We have what the statute is now, that probably recreational products would be drugs. But what should the statute say? What should FDA's role be in this space, if any?
I remember going to a conference where I forget which commissioner was there, but the last commissioner, it wasn't the last one, but anyway, one of the commissioners was talking about the fact that cannabis would theoretically be treated like any other drug. Why would we need a special office for cannabis as you see it?
So in this draft bill that I'm blanking on the name of it, but if I Google it's a draft Senate bill that came out, as I said, like August, September of last year. It would have created a Center for Cannabis Products for those products that are not marketed for medical uses. So somewhat, I think, analogous to the Center for Tobacco Products, the idea being if you're marketing a tobacco product or a tobacco-derived product for smoking cessation or other therapeutic uses, you're still a drug or device. Same would go, I think the idea was the same would go for cannabis, that if you're marketing cannabis for a medical use, still a drug or device, still treated the same way. But if you're marketing for a recreational or some other kind of more consumer use, that would have its own center. I think the lines, just from a statutory drafting perspective, I think the lines are a little harder to draw with cannabis. How do you explain what is a medical use and what's not, particularly when there already are these kind of overlapping markets in all the states, whereas I'm not sure that's quite the same with tobacco products. I'm not sure the markets were quite the same, but I think that was the general idea, that we wouldn't want to treat recreational products the same way we treat, oncology products, for example.
So let's address the question you sort of raised right there, right? You talked about this idea that there are non-therapeutic uses to cannabis. Could you give a couple of examples of what that would look like?
Well, I mean, I think like what the marketing would look like.
No, I should have been clearer. For me, when I think of the whole, and maybe it's to a man with a hammer, everything looks like a nail, right? So for me, when I think of cannabis, I'm thinking about your THC products, or and you're thinking about for anxiety as an anti-anxiolytic, or for nausea, or what's actually like Marinol stuff for appetite stimulation, etc. And then you've got your uses that are completely on from left field, which is you're going to build clothes with it, or like the hemp version. What is that middle ground that would theoretically be non-therapeutic?
Yeah, so I think it would be products that are marketed for recreational use, products marketed the same way, alcohol is marketed, or even it may be. I'm not clear entirely on the intent of what the draft bill was, but there might be kind of a gray area between a product intended to create a recreational high, a product intended to help with appetite, for quite ill patients, and some middle ground where we're, the sort of CBD-esque products that are intended to support wellness or, support sleep. the kind of dietary supplement type claims that we sometimes see in the market. So, there's kind of a spectrum, right, of products we might consider. But I do think, I take the intent of the draft bill to be recognizing that FDA statute as currently drafted gives the agency quite broad authority over the full range of cannabis products we might see, and that might not be what we want as a policy matter.
So talk to me a little bit about why that might not be what we want as a policy matter.
Yeah, I would be curious to know what you think and what your audience thinks. I'm not sure it would be such a bad thing depending on how FDA interpreted its authority. But, I think the idea might be that, safety and effectiveness might be tough standards to implement for a product intended, for example, to produce a recreational high. On the other hand, though, you could see, FDA has done this kind of assessment for aesthetic uses of products like Botox again, right? So FDA has operationalized safety and effectiveness outside the therapeutic context, granted not in the recreational use or adult use context, in the aesthetic context, but still FDA has operationalized it. And, I could imagine how if it could be a real public health boon to have a truly safe and effective, to have knowledge about how to use recreational products most safely and effectively. I think, human history suggests we're not all going to stop using recreational products of a wide variety anytime soon as a culture, as a people, right? So it could really be a public health boon, right, to know that there are safe and effective, or safer than what we currently have, and effective products out there.
So you asked me for my opinion. So everyone has an opinion. My question would really be, why the FDA? I would think that at least, I would think like alcohol, tobacco, firearms probably has a better sense of it because they regulate alcohol. I would say that FTC might argue that they have jurisdiction on the promotion of it. I think FDA would probably have better knowledge, better skill sets, better information on the manufacture of it. But I see the value in not dividing it across different agencies. That's just a nightmare, a bureaucratic nightmare. But why do you think it should be, from your perspective, why should it be FDA?
Yeah, I'm not sure it should be either. And I guess to be clear, and this is sort of outside my expertise, sure, there's also really complicated questions about how you create a legal market that, sort of helps to mitigate the racist history of, drug enforcement in our country, and the, disproportionate impacts that have been, suffered by people of color that, seems like something that's not also within FDA's expertise necessarily, right?
Right.
So
right.
There's I think there are a lot of complicated questions about how best to make a truly legal market. And so I say, so there's that caveat. And then, I'm not sure I have a strong view about whether FDA is the right agency to do it all, but I do think cannabis, to the extent that there are legitimate science-based hopes that there will be medical uses for cannabis products or cannabis-derived products, I do think cannabis presents a different question than alcohol. We don't use alcohol for anything medical, and I think there might also be questions about how do we simultaneously have a consumer market for a product while still preserving sufficient incentives for industry to do the research and development if there is real scientific hope there for treatments. So how do you have kind of parallel tracks? And FDA might be better positioned to manage that than other agencies, given its expertise in the sort of therapeutic market.
So I'm going to challenge you on that, because as a pharmacist, I've actually been in an ICU setting where we had to give alcohol to a patient.
Oh, okay. See, I'm not, yeah, okay.
And the reason you have to do that is because the patient was so addicted to alcohol that you can't just stop it. You literally have to wean them off. And then there are other indications that I probably should know what they are, but it's been a few years since I've worked in a pharmacy. But alcohol does have therapeutic value. I never quite looked into how it gets regulated in those cases, but I remember the whole conversation around the pharmacy was this thing's like extra concentrated. So I assume there's something like therapeutic alcohol. So I thought that was fascinating. So my point being, there is the equivalent of treating alcohol. And here we go. Tia Romero. We do use alcohol pills to help increase appetite in nursing homes. I did not know that, actually.
Yeah.
So this challenges what we know about alcohol. So if there is a dual management, if you will, of alcohol versus therapeutic alcohol pills, apparently, versus drinking alcohol for recreational uses, why couldn't you do the same thing for cannabis?
Yeah, I mean, I think that's the hope. I guess my question back to you and Tia, which I'm delighted that I've learned this. I'm really excited. And I have on my to-read list, I'm blanking on the title, not a good day for me on titles, but there's a history of alcohol that a historian at Harvard wrote that I've been meaning to read. So it's on my summer reading list. So there are therapeutic uses of alcohol, but I guess my question would be, are there uses that we have not found because no one's doing research on finding more uses, right? So part of it, it's not just regulating the existing proven uses, but how do we, if there is legitimate hope about the potential for a particular substance or product to have important therapeutic uses, important for the public health, how do we incentivize the research and development to actually to prove that those uses work, that they're safe and effective, widely market them, et cetera?
So I want to start off by saying this is not clinical advice, because this conversation is so off the rails at this point, which is so much fun. But I can totally see a future version, a future trial of alcohol as an anxiolytic. To see, I remember, okay, this might come from the movie, so I will admit my knowledge may be biased. But I remember, when you're in when they do reenactments of Civil War and stuff, they'd give each other alcohol before they chopped off a limb. So either as a sedation product or as a anti-anxiolytic, apparently alcohol could have those values. So I'm not sure that's the best place to get there. So why isn't that type of research done then is the question, right? Because it's not like it's not possible to do. We obviously have alcohol pills, and we obviously have value to it, the therapeutic value. So again, it brings back to the same question you were asking before. Do we really need a separate office to manage that? We don't have an office of alcohol use, or we don't have an office of anything else. So why do we need this special office for cannabis would be the question that pops up again.
Yeah, I mean, maybe we don't. I in terms of sort of why don't we see that research?
Yeah.
My worry, I guess, would be that it is actually really difficult to manage maintaining incentives to do the expensive clinical trials, the expensive research and development, when there's a widespread consumer market, and the traditional rewards that we give industry for undertaking all that work is market exclusivity, right? And kind of a guaranteed patient population where you may not be able to count on that quite as heavily if people can essentially buy over-the-counter versions, even if they're not as safe and effective or not as good for the person's condition. You still, there still may be more risk, right? In terms of whether we need a separate office, maybe not. But I guess, and again, I actually don't have a particularly strong view about this, but I would, I guess, push on the idea that creating an office within FDA, to the extent there are concerns about whether FDA is the right regulator to take on the question of how to manage what may become the federally legal cannabis market. I think creating an office within FDA is one way that often that is used to change institutional culture at FDA, to signify that, hey, this is an important issue. We need to build expertise in this area, a way to get money to build expertise in that area. So I do think it can have an organizational culture function that could be important to the agency taking on this role if that's where we're headed.
I hate to add this part again because it's just sort of interesting to me, but the piece you just raised, by the way, a few seconds ago, was this idea that in certain markets there are alternatives to the product, and that might be problematic. But I would challenge that in that, for example, Vasepa is your fish oils, which are widely available off brand, and they've had more than their share of legal troubles, obviously. I love, by the way, that you couldn't stand the idea that you couldn't remember the study.
Yeah.
So I will, because you have been very kind to share this. I'm going to share the link with everyone else so that people can see the link that was being referenced a few seconds ago. But so that's, if you go to the YouTube link, you should be able to see the Harvard study, the Harvard paper that was written. I assume that's the one on alcohol, correct?
Yes. Yeah. This historian wrote a book on the sort of history of prohibition and alcohol, et cetera. Yeah.
Yeah. I will also put it up as a banner so that people who are not going to the YouTube link can see this as well. So technically, what I was saying was, you have both cannabis, which is available recreationally, and you have what's the GW Pharma made a killing with that, and then you have Vasepa with Amarin that made a killing with their products. Both were sue happy, and I don't mean that in a bad way. I mean that they were protecting their interests. But there is precedence for companies coming in and saying, we have a better product, we are approved for a specific indication, and we're going to protect that. So one might argue that alcohol might have, and I don't know how we got into really just talking about alcohol, but somehow we did.
Only it were Friday. Yeah.
But I would suggest that Pfizer brand alcohol is not that far away anymore, just after this conversation. But
I mean, maybe not, but why hasn't it happened yet, I guess, is the question, right? And
the market's too small.
So maybe the market's too small. And if it's possible for, say, a pharmacist to use a consumer product to treat a patient, and it's a relatively inexpensive consumer product, is your market even smaller, I guess, would be the question. And point well taken that companies have made profitable prescription products where there are similar products available as supplements or otherwise, consumer products. I still think I still think there is a risk, right? There is some, it's not the typical development model that there's a parallel consumer market. And I do think it's worth considering whether, how to manage that optimally so that there are sufficient research incentives. There might be open questions about, well, would we have more prescription uses of CBD, for example, if it weren't widely available everywhere, and so on. So maybe that's an empirical question I can't answer, but I do think it is one that's worth considering.
What is your opinion on? And we're well past time. I'm going to ask this just as a last question before we close up. But so far, we've talked about alcohol and cannabis really from a federal management viewpoint. One of the we've always talked about states as the laboratories of democracy, I believe that's the saying. Hopefully I got that right.
Yeah.
The labs have been working for the last probably 10 years or so. And we have a sense of what different states have looked at and used CBD for. Do you think that the FDA will consider that? We'll look at the results of the different labs, and that's going to play a role in how they regulate CBD or cannabis overall.
So that's a good question. I think state legislatures' determinations about what indications cannabis or CBD may be marketed for within state borders are unlikely to be supported by the kinds of safety and effectiveness information FDA generally expects. And so from a marketing for therapeutic indications perspective, I'm not sure there's any reason to anticipate FDA deviating from its normal views about what kinds of evidence support safety and effectiveness. And that might be also part of the reason why cannabis is in a somewhat unusual situation. I think I'm not a historian of cannabis, but my general intuition is that some of the there's some blurring, right, of the medical and consumer markets at the state level. There may be other reasons why states would allow really quite broad access to many, many indications that may not be tied specifically to views of safety and effectiveness, and might be tied, to concerns about how, drug policy has played out in our criminal justice system or other things. I don't think there's a reason to expect that at the therapeutic level, FDA would do anything differently or significantly differently.
Sorry, I said that was the last question, but we're going to ask one last one. Do you think whatever they do with CBD or cannabis will end up being a template for other products, like, for example, psychedelics that we talked about?
Yeah, maybe. I think that's a really important question for Congress and FDA to think about as cannabis reform moves forward, because it could serve as a template for other, especially other botanical recreational products. I mean, I think, there are some differences, right? I think the public perceptions around cannabis and psychedelics are probably different. The safety profiles might be different, those kinds of things. But I do think that's an important issue to keep an eye on.
Awesome. Before we go, how can people reach you?
So you can reach me on Twitter at P Zettler, or at my Ohio State email address, which is right up there on the screen, zettler.25@osu.edu. So thank you. This was a great conversation. Really appreciate the audience chiming in. I learned a lot. So it's always a lot of fun to chat.
Thank you so much for coming on. I can't wait to have you back again soon.
All right. Sounds great. Thanks again.